Presenting today's webinar, Busting Common Myths About Shippers' Loads and Counts, is Gerad Smith, partner in the law firm of Pezold, Smith, Hirschmann, and Selvaggio, LLC. So without further ado, I am pleased to turn the program over to our presenter. Take it away, Jerry.
Thank you, Patricia. Good afternoon, everybody. We have a number of people here on this afternoon. Very cold here in New Jersey, about 15 degrees where I am. But we're going to talk about busting common myths about shippers' load and count. When I first came to this group, I found out that many of you attending a seminar similar to this were vendors. And they were a little bit surprised by the information they received in this type of seminar, especially as it relates to carriers. And we're unaware that they had a possible claim against the carrier as it relates to losses when a shipment was loaded at or entitled shippers load and count. So we started explaining to them that there is information that they might be missing in this type of situation. Now, many retailers that the vendors deal with mark their shipments shippers load and count, and they charge back to the vendor, and the vendors are at a loss as to what to do, or do they have a claim against either their retailer or the carrier, and they suffer shortages and they're without a remedy. So we're going to try to explain to you the theory behind shippers load and count, and try to give you some information about shippers load and count and where it comes from, and explain to you about claims in general. So most carriers will tell you as long as there's not been an altered or tampered with with a consignee, a shipper cannot question or hold the carrier liable for a shortage because the carrier was not present at the time of the packing of the container, and the carrier doesn't know what the shipper loaded, stowed, or counted. Are the carriers right? Increasingly, to prevent cargo damage, more product is shrink wrapped prior to loading, and that makes piece count impossible. Drivers' hours of service changes have led to more spotting of trailers loaded and unloaded after delivery without drivers being present. Because of workers' comp claims, many warehouses are refusing to allow drivers to be present on freight docks when a shipment is loaded and unloaded. All these things are true. Additionally, the shipper, not the truck driver, is most familiar with the fragility of the product and best loading procedures. That may or may not be true. As a result of the carrier's claim, shippers load and count should be the norm for truckload shipments. That's what carriers are claiming today. Most carriers by contract, by means of their tariff, and I don't know if people understand that carriers have tariffs. They have a document in their office, which they keep, which is incorporated there by their bill of lading, or maybe incorporated by their contract, that have provisions in them that you may or may not know about, such as shippers load and count. And these documents are very important that you do know that what's in these documents, because they are important to have, you have knowledge of them, and they state certain things that have to be done. And a shipper's loading, a carrier's tariff or a contract may say, shippers load and count. All shipments shall be loaded by the consignor, which is the shipper, and unloaded by the consignee. Carriers' drivers are instructed to sign bills of lading as shippers load and count, or SL&C. Inadvertent omission of the notation shall not result in a presumption of the carrier's liability for shortage and damage in the absence of an accident or where the driver was either not present or not allowed to observe or load and unloading. That's very important, where the driver was either not present or not allowed to observe the loading or unloading. Not present? I don't know about that. So you have to really, we're going to discuss what that means. Now, liability for loss and damage and delay to shipments is under the federal law provisions of the CARMACK Amendment, which is 49 USC 14706. This is the Interstate Commerce Act, and it covers all liability for loss and damage claims throughout the United States. It's a uniform uniform liability for damages throughout the United States, and it governs all loss and damage claims throughout the United States. We don't have a different rule of law for New Jersey or California or Florida or Illinois. We have one rule of law for all loss and damage claims, and that's the CARMACK Amendment. The CARMACK Amendment came about with Edward Carmack, who was an attorney, a newspaperman, and served as a U.S. Senator from Tennessee from 1901 to 1907. The federal law governing surface carriers, which are motor carriers, the loss and damage claims and delay to interstate commerce movements, was commonly known as the CARMACK Amendment, and it was named after the senator responsible for acting the law. What's interesting about Senator Carmack is he was shot to death. He was from Tennessee, the land of Jack, and he was for prohibition. You can't be for prohibition from the land of Jack in Tennessee. It just doesn't work. But he did enact the CARMACK Amendment, and it's very important. And it's, I don't know why there's two laws. It used to be one. But in 1996, the Interstate Commerce Act was amended. And it's the CARMACK Amendment 49 USC, which is the United States Code. That's what it stands for. It's the United States Code. 14706 applies to motor carriers, and 14 USC 11706 applies to rail carriers. And it states, in essence, carriers are responsible for the actual loss caused by the carrier by reason of loss, damage, or delay. Now, a lot of times carriers will say, well, we're going to take that word delay out of the contract. That doesn't really apply. But it does say by reason of loss, carrier, damage, or delay. And delay doesn't necessarily mean under the CARMACK Amendment, you know, if you don't deliver my goods by a certain date, then you're liable. That's not what delay means under the CARMACK Amendment. Delay under the CARMACK Amendment means reasonable dispatch. And I'm not going to get into all that today because that's not what we're talking about today. But delay has a certain meaning under the CARMACK Amendment. Carriers are considered virtual insurers of the goods in their possession. So the CARMACK Amendment set forth a uniform standard of liability, and the end of the conflict of state courts of the extent of liability. In other words, no longer do states have different liability regimes. It's joint and several liability for the origin and delivering carriers. What does that mean? It means that if a carrier picks up the goods and gives it to another carrier, both carriers are liable for the loss, even though the loss may have occurred while in possession of the delivering carrier. The origin carrier may also be liable, and they are jointly liable for the loss that may have occurred. It requires the carrier to issue a receipt or a bill of lading. So they're required to issue a bill of lading. it codified the common law of liability. In other words, there was law, as we called it, the common law. And it really came from England, and we built on that in the United States, and it codified it. In other words, it made it code. That's what the United States Code is. It made it one load, and that became the CARMACK Amendment. It preempts state law. In other words, state law doesn't apply. The CARMACK Amendment applies to all shipment of goods throughout the United States. Interstate commerce, commerce between the states. It enacted uniform time limits for filing of claims. You've heard about 9 months and 2 years and a day for claims. So 9 months to file a claim and 2 years and a day from the date the claim was declined. Place where the carriers may be sued is venue, and that's set forth in the CARMACK Amendment. And originating and delivering carrier required to pay for the loss. No longer is it just one person liable for the loss. Now, liability begins with a carrier when the carrier picks up a shipment. The shipper must complete delivery to the carrier, and the shipment must be accepted by the carrier. And that happens by one of two ways. Either the carrier issues a bill of lading and accepts delivery. So if the carrier issues a bill of lading and signs that bill of lading, even though it may not have picked up that shipment, that carrier has accepted delivery of those goods. Or it can physically pick up the container, and that's accepting delivery of the goods. Liability begins when the goods are placed in a position to be cared for, and it's under the control of the carrier or his agent. With his knowledge and consent, shipper must give the carrier appropriate shipping discretion. So, in the case of Conair versus Old Dominion Line, and this is a very famous case, it's what we call the seminal case on this area. In other words, the case that everyone points to. Conair's employees had loaded a trailer owned by the carrier. Upon completion of the loading, one of the carrier's drivers signed the bill of lading. The driver, however, did not remove the trailer, and Old Dominion arranged to have another driver pick up the load later that evening. When the driver arrived, the trailer was missing, presumably stolen from Conair's premises. Old Dominion trailer was loaded and prepared for transportation the time they signed the bill of lading. There was no further action required by Conair before the transportation of the shipment by Old Dominion. Was the carrier responsible for the loss? Yes, it was, because they signed the bill of lading, and even though they didn't pick it up, they were responsible for the loss. When does liability end for a carrier? Well, liability does not end until the transportation of the shipment is completed. Transportation is not completed until a shipment has both arrived at its destination and has been delivered. So, during the presentation, by the way, if you do have a question, we'll do them at the end. But if you have a presentation as I go through it, you can stop me, raise your hand, and Patricia will tell me that there's a question because I can't see anything. And you can ask me a question.
I would be glad to do that. And just to let everybody know, if you have a question and want to raise your hand within the list of attendees, I will watch for that and bring that up. And we do have one question waiting in the queue for the end of discussion.
All right. For the end of the discussion or for now?
Well, I can raise it now if you would like. Are you willing to take it now, Jerry?
Yes.
Okay.
Absolutely.
Our question is, if a carrier cannot provide us with a copy of the bill of lading or proof of delivery, are they responsible for that shortage?
If they don't provide you with a bill of lading?
If the carrier can't provide us with either a BOL or a POD, are they responsible for the shortage?
If there's a shortage and they can't provide you with a proof of delivery, yes, I would say they would be. Yes, I say that's a very good reason if they can't provide you with a proof of delivery, sure. Yes, that would be a very good reason to say that they're responsible for for a loss. They're certainly required to provide a POD and a bill of lading. Of course, they're responsible. Under the law, a carrier is required to issue a bill of lading. And by the way, only a carrier can issue a bill of lading. A shipper prepares the bill of lading 9 times out of 10, but a carrier can only issue a bill of lading. Under the law, only a carrier has the authority to issue a bill of lading. And I'm not going through the different modes. There's brokers, there's carriers, there's freight forwarders, etc. And there's 3PLs. 3PLs actually don't exist by law. They're non-existent under the Interstate Commerce Act. Freight forwarders and carriers have authority to issue bills of lading. Brokers do not. Brokers arrange for transportation. That's their only ability to do that. They hire freight forwarders and motor carriers to ship the goods on behalf of their customers. That's all they do. 3PLs more than likely have authority as brokers. That's all they have. They don't exist by law under the Interstate Commerce Act. They have no authority. A lot of you may be brokers, but you don't exist by law. Now we have shippers, we have carriers, and we have the consignee, which is usually the retailer in your particular case. All right, that's the consignee, and we're going to get into how you deal with that, especially on the chargeback situation.
Thank you for taking that question, Jerry. We do have another question that has come up. Do you want to take that, or do you want to continue into the presentation?
Exactly. No.
Okay, here we go.
More questions.
Absolutely. We've an engaged audience. What is the difference between preparing a bill of lading and issuing a bill of lading?
Preparing the bill of lading, the shipper normally prepares the bill of lading. In other words, he puts where the shipment, the type of goods that are being shipped on the bill of lading, the consignee, et cetera, and so forth. But the carrier issues the bill of lading. In other words, the terms and conditions of the bill of lading, the terms and conditions of the bill of lading can only be set forth by the carrier. The shipper, unless he has a contract with that carrier, cannot dictate the terms and conditions of the shipment. In other words, that's governed by the carrier's tariff. And it's governed by the carrier's tariff. It can't be governed by the shipper. Shipper has no right to do that. So unless there is a contract with the carrier that says, we're going to use my bill of lading, that is the shipper's bill of lading, and my terms and conditions are going to control. The only person that could issue or dictate the terms and conditions of the contract are the carrier, and the carrier's terms and conditions of its tariff and the back of the bill of lading. And that's a course for another day. I teach a course called Freight Claims in Plain English, where I go through all this. And that's, what we talk about. What are the terms and conditions of a bill of lading? I go through that. I go through a carrier's tariff and terms and conditions, and we talk about those things. But that's a different item altogether. Terms and conditions of a bill of lading are solely the provenance of a carrier. They own the terms and conditions. They own that. And so they're the only ones that can issue a bill of lading. They're the ones that have the right to do that. Again, unless there's a carrier, contract, excuse me. It's only a long day. I'm a judge, a municipal court judge, might have read. So I did court all morning this morning. So my voice is going a little bit slow on that. But anyway, unless the carrier has a contract with the shipper saying, we're going to use my terms and conditions, then only the carrier could issue, only a carrier can issue a bill of lading.
Thank you,
Any
Jerry.
other questions?
We do have other questions pouring in, but I am watching the time and I'm concerned because I do want you to get through the whole of the deck. So do you want to continue on for a little bit and then
Well, let me
please continue to give us
continue on, and
questions?
then we'll do some more questions, all right?
Absolutely.
All right, so the first element of proof under the CARMACK Amendment is you got to prove good order and condition. In other words, you got to prove what you loaded onto the truck, loading tallies, packing list, bill of lading, the invoice. So that's the first element of proof. Let me get through this quickly. Second element of proof is non-delivery, damages, or delay of the goods. The third element of proof is the actual value, and it's always destination market value. Carriers may say it's manufacturer's cost and things like that. It's destination market value. That's the measure of damages. It's what you sell it. Vendors, what do you sell it to your customer for? What do you sell it to the retailer for? That is the measure of damages. It's not what you buy it for. It's what you sell it to your to the retailer for. It's destination market value. It's never manufacturer's cost. I see that so many times. I see that with, where the carrier will say, we're not going to pay that. The law is very clear. As a matter of fact, my case and my partner's case are what they call the seminal cases throughout the country that are cited all the time. This is called Paper Magic, the Paper Magic case. And it is the case that talks about the measure of damages being the destination market value. And if you ever have a question about that, you can write us an email and I'll send you the cases that talk about destination market value. All right, so now we get into shipper's loading count. This is why you were here, all right? Shipper's loading count. What's the legal effect of shipper's loading count notation on a bill of lading? It does increase the claimant's burden of proof substantially. It places the burden of proof and correct loading upon the shipper. On a shipper's loading count shipment, claimant loss and benefit of prima facie showing a good condition at origin created for non-shipper's loading count shipments in those situations where carrier is able to see the goods during the loading process, signs a bill of lading without exception. So what does that mean? In a non-shipper loading count shipment, where the carrier can see what was loaded onto, or where you can actually see what was loaded into the truck, and he signs the bill of lading and doesn't note any damages, there's a presumption that the goods were received in good order and condition, and that's all you would need to prove good order and condition. Remember, good order and condition, damages at delivery, and then you have to prove the amount of damages, destination market value. So on a shipper's loading count shipment, you lose that benefit because the carrier cannot see what was loaded onto that shipment because it's been sealed. He doesn't know what's loaded in there. And so that type of shipment, you lose that presumption of seeing what was there. So there's no showing of good condition at origin at that particular point. Let's go. The general rule is that if a bill of lading contains shipper's loading count or a similar notation, it creates a presumption, and presumptions are rebuttable under the law, that a carrier has expressly disavowed any agreement as to the quantity and quality of the goods received. The claimant is required to prove by other evidence the quality and quantity of the condition of the goods at origin and the destination, and if they were properly conditioned of the goods loaded. Change the view here. Oops, I don't know what happened. That's properly loaded, such as having a manifest, packing list, stroking tallies, loading tallies, diagrams, digital photographs, or other evidence as to what was actually shipped. Actually, the best evidence is having the person who actually loaded the goods see what was actually there, if that's possible. Those are the best things to do on a shipper's load and count. It's not as the carrier says. We can't be liable on a shipper's load and count. That's not true. That's just not true. There is a presumption, but it's rebuttable. And as long as you can show that the goods were loaded, loading diagrams, that it was properly loaded, blocked, and braced, then you can rebut the presumption that the carrier, that the goods were loaded properly and that those goods were loaded in the truck at the time at origin. If a shipment was actually loaded and counted by the carrier, and the carrier had an opportunity to inspect the goods, and a notation was added gratuitously, that's a problem. So if a carrier has the opportunity to inspect the goods, but still marks the bill of lading SL and C, that's a violation of federal law, and it's a criminal offense, believe it or not. Now, I doubt any U.S. attorney is going to file criminal charges against someone for doing this. And we do have contracts by certain large companies, let's put it that way, and I have seen them, which require that SL and C be marked on the bill of lading on goods that may be charged back to a vendor, even though the carrier can in fact view the load as it's loaded, but still there is a requirement that the bill of lading be marked SL and C. That's a problem. That's a real problem. So how do you deal with that? Well, it should be emphasized that SL and C notation is only proper when the carrier's driver is not present and is not afforded the opportunity to observe the loading of the vehicle. If the driver does have an opportunity to witness the count and the condition of the goods being loaded, but chooses not to do so, goes for coffee, takes a nap, SL and C notation should not be entered on the bill of lading. So if the driver insists on putting this on the bill of lading, you should make the notation that the driver was in fact able to see the load and chose not to do so. And if, let's say, you don't allow the driver to go onto your dock because of workers' comp situations or whatever. However, before the doors are closed, you have the driver pull the truck away so that he can view its contents, and he chooses not to. You may want to note that and say, well, this can't be an SL and C shipment because the driver refused to look, although we gave him an opportunity to do. And, you know, if there's a shrink wrap situation, he may not be able to make it up, a very good count, but he can count certainly maybe the skids or whatever the number of items are in that particular shipment. Then it's not an SL and C shipment and shouldn't be marked as such. Shipper's loading count on a bill of lading signifies the shipper loaded and counted the shipment. If there is a loss or damage discovered upon the delivery, the claimant cannot rely on quantity or description of the bill of lading alone. There's an additional burden of proving the quantity of the goods that were loaded on the trailer. And we said, such as manifest. Digital photographs are very important today. You know, everybody's got a camera. You should be able to take pictures. I mean, it's just very simple to do something like that today's day and age. All right. To prove a shortage, delivery of the goods in initial carrier in good condition. Okay, damages, the amount of the damage of the goods before delivered to final destination, the amount of the damages. Courts have held that where the merchandise is a sealed container are not visible to the shipper must establish direct evidence that the goods were delivered to the carrier in good order. I will tell you, I just had a case, a lot of cases. I have tried a lot of cases in the Southern District of New York, which is Manhattan. And it is extremely difficult in today's day and age, especially on a shipper's loading count. I'm not going to kid you that to prove good order and condition, and judges take a hard stand on this. And it's very difficult to prove this. I just had a case recently where the shippers hired a expert to look at the goods, and his own expert said that they did not load the goods properly, et cetera, and so forth. Really caused the problem for the shipper. His own expert kind of said that they didn't do things properly. And the expert was a young guy who never really knew anything about the type of goods that were being shipped, but caused a real problem for us in this particular case, because he was the one that was present when the goods were unloaded. And so we had to hire another expert to rebut him and say, well, this kid really didn't know what he was kid, I say, because he was only been doing the work for 2-3 years and really had no idea what the product was, how it was to be packed or stowed or loaded. And so we had to overcome our own person, so to speak, to prove good order and condition. And that's usually the hardest part of the burden of proof, is to prove good order and condition in any particular case. And judges are very tough on shippers improving good order and condition, especially in shippers load and count situations. They look at that it's almost impossible unless you do exactly what you say. You know, you have delivery receipts, you have maybe photographs. The best evidence is to have somebody who actually loaded the goods, et cetera, and so forth. And in this particular case, we did have that person who actually loaded the container and observed the loading of the container. And that was very strong in us proving our case ultimately. And this guy had been doing it for 40 years. And we butted the presumption of the person who unloaded the container and said, well, we didn't do this right, we didn't do that right, we didn't do this right, et cetera, and so forth. And this person just said, look, this person doesn't know what he's talking about. We've been doing this for 40 years, never had a problem. And this one container, actually it was 2 containers that were damaged were because of the carriers, because the carrier improperly shipped these goods. So, I mean, they really take a hard line on this. And that's very difficult. So I will tell you, it's a difficult burden. Courts have long held that improper loading is apparent, could have been detected by the carrier's employee. The carrier cannot raise the shipper's act as a defense. So if the carrier's employee can detect that the shipment is loaded improperly, the carrier cannot say, well, it was their fault. So if they feel the load will shift they cannot raise this as a defense, and that happens quite a bit. If the shipper is not willing to accept the consequences of the shipper's load and count this notation, seal trace should be accompanied by another notation on the bill of lading requesting inspection by the driver of the cargo after loading. So if you say, if the carrier goes, well, I got to mark the shipper's load and count, you should say, wait a minute. Well, you can go in and inspect these goods. It's not a shipper's load and count. We want you to take a look at the shipment before we seal this container. And shippers should request drivers to check loads before acceptance. If a driver refuses to do so and had the opportunity to do so, record in your records what the driver was doing when you loaded the shipment. Do not permit the driver to insert shipper's load and count on a bill of lading that has been given an opportunity to inspect and count the load during loading. In such cases, insert affirmative statement. The shipment is not a shipper's load and count shipment, and the driver is to inspect and confirm the load. The effective loading shipment by bill of lading is only established if the carrier has not counted, does not guarantee the number of packages. Such words do not relieve the carrier from liability for loss and non-delivery of the goods which were actually received from the carrier by the shipper. By other means, bill of lading, shipper load concludes that what merchandise was delivered, carrier was liable for goods it did receive but failed to deliver to goods. So it really has to do with, if the goods are damaged, certainly shipper's load account has nothing to do with that. It only really comes into play where there is non-delivery of goods. Nothing to do with damaged goods. That's basically what that is saying. So how do you have an immediate inspection? Damages of goods. Do not wait until the damaged product is returned to origin. Inspection for salvage. Use digital cameras. And we keep saying that. And you've got to check a carrier's current tariffs. How many of you would know that a carrier even has a tariff? And what is a carrier's tariff? And how do you find out what's in a carrier's tariff? Most carriers have their tariffs online. And any carrier today that doesn't have their tariff online really is, you probably don't want to use that tariff. Because every carrier has a tariff. And how do you get a carrier's tariff? You got to ask for it. They're not going to give it to you. They don't have to give it to you. You got to ask for it. And then they have an obligation to give it to you.
Jerry, my apologies for breaking in. This is Patty here. Just wanted to give you a quick time check. We have approximately 20 minutes left until we are formally done with this presentation. I know you indicated that you would be able to stay a little bit longer to take questions. We do have 8 questions currently in the queue, and I think we're about halfway-ish through the deck. Do you prefer to continue on with the deck, or do you want to take some questions at this time? What's your preference?
I'm trying to figure out, like I said, I did not time this one out because it was a newer presentation that I made.
It's a wealth of information.
So I'm going to, I'll take some questions now.
Okay.
We just did that.
Absolutely. Glad to. First in the queue is, should the shipper be able to get a proof of delivery if it is a collect shipment?
Why not?
Okay. That doesn't make a difference.
All right. We're going to get into that. That's exactly my next topic. We're going to talk about, collect shipments and what that means and things like that. So I don't want to confuse collect shipments and risk of loss and things like that. That's coming up in the next segment. That's a good question.
Okay, perfect. Let's just move on to another quick question or two, and then we'll return you to your presentation. Let's see. What reference would we use when we tell a carrier that they can't, if they can't provide a POD, they are responsible for the shortage. So they're looking for a legal reference, I would imagine, that they could point to for the carrier. If
they can't provide a proof of delivery, then they're liable for the loss. How are they going to prove delivery? How do they prove they delivered the goods without a POD? That's such a a custom in the industry that, you know, they have an obligation to prove that they delivered the goods. They haven't delivered the goods. Good order and condition. Proof that they delivered the goods. POD does that. They haven't proved that they delivered the goods. How are they going to prove it? So the second element of CARMACK is missing. So remember CARMACK, all right? Good order, deliver to the carrier in good order and condition. Delivery by the carrier, and damages, destination market value. If they have no POD, how are they going to prove that they delivered the goods? That's your
Got it. So CARMACK is key there.
CARMACK, that's why I brought up CARMACK. CARMACK is the key to the whole thing, to the shipment, all right?
Excellent, thank you.
I mean, I could get into more detail, but CARMACK is your key. That's why I brought it into this, all right?
Perfect.
Go ahead.
Another quick question. What if the carrier does not sign the bill of lading?
That really, I mean, you know, you should have them sign the bill of lading. I mean, you can note it that the carrier refused to sign the bill of lading. You want to note it? Note it. That's all.
Okay. All right. Makes sense.
Oh, and I mean, you know, what does that mean? It means that they should sign the bill of lading, but note it. The carrier refused to sign the bill of lading. That's what I would do.
Okay. Sounds good. Next question. If the value of goods is actual value, why do we indicate the NMFC and freight class on the bill of lading that typically references a value, such as 90 cents per pound?
The National Motor Freight Classification only comes into play if the carrier actually belongs to the National Motor Freight Classification, if it applies to, and if its tariff incorporates the National Motor Freight Classification as a limitation of liability. Now we're going back to tariffs. Boy, you guys we're in a different course. I mean, the National Motor Freight Classification incorporates a limitation of liability in a carrier's tariff. A carrier tariff can limit liability, okay? So if there's a limitation of liability in a carrier's tariff and they belong to the they have to belong. In other words, they have to pay a fee every year to get that benefit of the national, to get that limitation of liability. So there's a whole bunch of rules off of that. Again, freight claims in plain English, I teach all this stuff. But it means that there's a limitation of liability in a carrier's tariff, and that would apply to any particular shipment. Doesn't mean 90 cents per pound, it could be something else. That's why if you are dealing with a carrier, you have the ability to contract with that carrier, you should. In today's day and age, if you're not contracting with a carrier and you have the ability to contract with that carrier, you should certainly do so. And so in today's day and age, every shipper or everybody should be contracting with the carrier. You set forth the terms and conditions of limitations of liability, et cetera, and so forth. And it's almost an essential part of doing business today.
Thank you very much, Jerry. Jerry, I'm going to give you one more question, then return you to your deck and hopefully be able to take the few other questions that are in the queue afterward. Next question is, we ship to all 26 DCs for Target, all on pallets, and there's really no time to take pictures of all their shipments. What other ways can we dispute the carton shortage claims? And they do note also that they almost always, when they, with Target, they do mark SLC on almost every load. So just
well, you're shipping to their DCs, right?
Yes. Mm-hmm.
And you're required to mark SL and C on every shipment that you ship with them?
No, I think actually it's two comments, and perhaps I've confused things by adding those together. The real question here is, they ship to 26 DCs for Target, all on pallets. There's no time to take pictures of those shipments. What other way can we dispute the carton shortage claims?
Well, you know, I mean, if you're loading the goods and dispute the shortage if you file a claim with the carrier. If you're loading the goods and then they are short when they're delivered, there should be a notation on the bill of lading, first of all, when they're delivered to Target, and then you file a claim with the carrier. And if they're charging you back, that's when you file the claim with the carrier and say, hey, look, Target says they weren't delivered, and you're proving good order and condition. Do you shrink wrap your load? There's a lot of questions there. So what I'm going to ask you to do, when you have these good questions, there are a lot of things I would need to know other than the way it's being formed here. Do you shrink wrap the load? Who counts them? How is the bill of lading marked, et cetera, and so forth? Is it cartons, et cetera, and so forth? So what I'll ask you at a particular time is you'll have my emails. You could always write to me, and I'll write you back, or I'll even call you, and we'll talk about these things, and I'll try to give you a better answer than we can today. So there's a little more information I would need to give you an answer on this, a complete answer.
Thank you, Jerry. And the questioner did provide a little bit of follow-up information, but in the interest of time, and my apologies to the person asking the question, but please follow up with Jerry via email, as he has so kindly offered. I'm going to return you to your slide deck for a few more minutes to kind of speed through what you have there. We will be sending out a link to the slide deck to everyone, and then maybe we'll have time to take a few more questions.
All right.
So
the Uniform Commercial Code makes the law of sales in about 50 states. All right. The UCC is what is very important. And why do I bring up the UCC? Because there are different modes. So FOB origin, you probably have heard of this, means risk of loss or damage in transit is on the buyer. So what does that mean? So once the shipper gives the goods to the carrier, the risk of loss, so if there's damage to the goods, it's the buyer is responsible for filing a claim with the carrier. Okay, so if there's no statement on the bill of lading, then it's by default goods move FOB origin. FOB destination means the risk of loss or damage in transit is on the seller. All right, so FOB destination. So goods are moved means the risk of loss and damage is on the seller. So until the goods get to the destination, it's the seller's responsibility, the vendor's responsibility in this particular case. Does that always happen? FOB origin, risk of loss and damage in transit is on the buyer. So you sell to Target. Target gets the goods, they're damaged. They charge you back. What do we do? All right, so I have to get through this. So there's a difference. So you have risk of loss, and then you have freight charges. The difference between prepaid and collect. Prepaid means the shipper is responsible for the payment of freight charges. Collect means the consignee is responsible for the payment of freight charges. Prepaid collect means the shipper and consignee is responsible for payment of a portion of the balance of the freight charge responsibility of the consignee. That's not really important. What is important is prepaid. Prepaid, the consignor is responsible for payment of freight charges. Collect means that the consignee is responsible for the payment of freight charges. Remember that. So we have risk of loss on one hand, and prepaid and collect has to do with freight charges. Risk of loss, freight charges, two different concepts, but people often confuse them. So you got to make a distinction here. And the distinction is title to the goods are sales terms. Risk of loss is goods in transit, and prepaid and collect have to do with freight charges. Title to the goods. So title to the goods is I sell a machine to a company. My sales terms are they don't have to pay me for a year or two. They're paying over a period of time. They don't own the machine until they pay me in full. That's the sales terms. Risk of loss is the goods are in transit. So the risk of loss may be totally different. So risk of loss is once I FOB terms, once I give the goods to the carrier, the risk of loss is on the consignee. And then FOB destination, the risk of loss is on the shipper. Prepaid and collect has to do with freight charges. Prepaid, shipper pays the freight charges. Collect, the consignee pays the freight charges. So different terms for different things, and they're often confused. Freight prepaid indicates the shipper or the consignor is responsible for shipping charges, as well as any ancillary charges. So terms like FOB origin, freight prepaid, in this scenario, the buyer takes ownership of the shipment when it's picked up by the carrier. Buyer takes ownership of the shipment is picked up by the carrier. However, the seller maintains responsibility for the cost and safety of the shipment. Freight prepaid, FOB origin. FOB destination, freight prepaid. In this scenario, the seller maintains ownership of the shipment. Throughout the shipping process, is responsible for the cost and safety of the shipment until delivery. Freight collect. Freight collect is, in this scenario, the buyer or receiver of the shipment takes ownership as soon as it's picked up by the carrier. At the origin pickup location, the buyer is also responsible for the cost and safety of the shipment until arrival. So he's responsible for the freight charges, FOB destination, freight collect. In this scenario, seller maintains ownership of the shipment throughout the shipment process and be responsible if something were to happen to the shipment. However, the buyer is responsible for the cost of the shipment. So FOB destination, shipper is responsible if anything happens to that shipment, but the buyer is responsible for the freight charges. A little different. So don't confuse the different types of things. There's freight charges, there's risk of loss. The two are not to be confused. Those slides are actually pretty good to refer to because those slides will tell you the difference, and you often confuse those concepts. Bills of lading will be signed, shipper's loading count by the shipper and the carrier, and the shipper or the carrier's failure to approve shipper loading count and bill of lading will not change the liabilities of either party. And that's contract language by usually contained in a contract by a carrier. Bills of lading will be signed, shipper's loading count by the shipper, and the carrier, the shipper or carrier's failure to include SL&C on the bill of lading will not change the liabilities of the party. How many of you have seen this on your retailers' shipments that require this language be included on all contracts with their carriers? And this is what bothers me. I've had lawsuits with this type of language against both the retailer and the carrier, and they've been settled because they don't want to see a reported decision on this. Both the carriers or the retailers don't want to see, and I went after a rather big retailer on this. Unfortunately, they just declared bankruptcy, but in any event, I went after a big retailer on this issue on a very large claim, and I pointed out the criminal statute in my lawsuit. And not to mention that they were going to go after them criminally, and we have to be very careful as lawyers not to threaten criminal acts. And the only way I could include it was by including it in the complaint, and that's the only way you can get around that situation. I can never write a letter and say we're going to charge you with a crime. That's unethical for an attorney to do. But yeah, it is certainly something, because these shipments were not, in fact, shipper's loading count, because clearly the carrier had every opportunity to observe the loading of these shipments, but was required by contract and was told by their company, carriers were told by their company they had to mark these shipments SL and C. And so, and they were doing that. And in this particular case, as I've indicated, they settled these cases because they did not want to report a decision pointing out the illegality of these type of contracts. I was kind of upset that my client wanted to settle it, but it was a good result, so I couldn't say anything.
Jerry, Patty, interrupting again, and my apologies for doing that. We have a little less than 5 minutes remaining in the formal time for this webinar. I do have questions continuing to pour in. Would you like to, at this point, perhaps go to the last page of your slide with your contact information, leave that up, and we can maybe take some of the questions. And if you're willing to stay on and people are able to stay on a little bit longer, we can do that.
The next part was really concealed loss and damage. We'll skip that. Your conference is in Clearwater, Florida.
Coming up in May.
Place. If you've never been to this place, and I have, it's a wonderful place. The Marriott Suite on Sand Key. It's one of the beautiful places in the world. Susan Haupt is the person to contact. It is a wonderful, wonderful trip. Hopefully it's in May. You'll get a copy of the presentation. It's on their website. I got this off their website. I asked them if I could include it in the slide presentation. So it's in May 1st to May 4th. It would be a great trip to take, May 1st to 4th. You can't beat it. It's really, really nice place. So if you could go there, do so. It's a wonderful seminar. They do a great job. They really do. And so hopefully you do it. On the other hand, not on the other hand, but we also have a conference. Ours is in March 21st, March 23rd at in Orlando. Ours start on Sunday, where I give my seminar called Freight Claims in Plain English. It's a full-day seminar, and my partner gives his seminar called Contracting for Transportation and Logistics Services. But they're both start on Sunday, and they're full-day seminars. And then Monday, Tuesday, and Wednesday, we have our programs that we do. We're a little bit different than, of course, your group. We do more claims and things like that. We represent shippers, brokers, and carriers come to our program, and we discuss the various issues. Unlike this group has retailers and vendors, the shippers load account. We discuss issues affecting all of those. We started out as a shippers group. We blossomed into a shipper, broker, and carrier group. And we discussed the various issues amongst those particular groups. So there's our particular slide. If you'd like to attend our seminar, it will be March 21st to 23rd in Orlando, Florida. We're in Disney World, I think, in their village or whatever the heck it is. I don't know where we are this year. So you'll have the slides for both. Go to our website if you'd like to do that. And I want to thank everybody for permitting me to do this. I enjoyed it. So now we have questions, and we'll do those.
Thank you very much, Jerry. We do have some questions we're going to go into, but just before we do, for those that may have to drop, I want to share Jerry's contact information. Jerry can be contacted at either gsmith@transportlaw.com or gsmith@pshslaw.com, and I will send up an email in about an hour or so with a link to the on-demand video and to this deck as well. So watch for that. All right, first question we have here is it allowable for a shipper to modify a bill of lading to include a checklist for the documentation that was included in the shipment, such as a packing list and GS1 128 labeling, and then say that the driver's signature proves that the paperwork was there?
No.
No? Okay.
You know what, for a client of ours, and I would name a rather large client who shipped electronic goods, we said that the packing list was the bill of lading, but that was contracted for. So we made the contract state that the packing list was the bill of lading, and the driver had the obligation to sign the packing list as proof that they received the goods as the bill of lading. As I've indicated to you, only the carrier can issue the bill of lading. If you contract for that you can do that, then yes, you can do it. But you just can't modify the bill of lading. Understand, that's a problem, because only, again, the carrier can issue a bill of lading. You can try to do it. In today's day and age, I have seen judges. Now, judges don't, I'm a judge. So judges don't understand the law of transportation necessarily. So if you do it and a judge buys into it, well, judge will say, hey, look, you signed it. You changed it. Why did you sign it? And then the carrier would have the obligation to say to the judge, hey, judge, they can't do that. What they did was wrong. And you may get away with it, quite frankly. So normally I would say no, but in today's day and age, I've seen some crazier things in the world. I've seen some decisions lately that I shake my head at. So although I would initially say no to you, if you do it and it works, good for you.
Makes sense. Thank you. Moving on, Monique, thank you very much for your feedback. Appreciate it. A question coming for you. With the current pandemic going on, we have recently seen signatures with large carriers being COVID-19. Is this a valid signature to dispute carton shortage claims?
Say that again?
Okay. With the current pandemic, they have recently seen signatures with large carriers being COVID-19 in quotes, so that's what they're putting on there. Is this a valid signature to dispute carton shortage claims?
I don't even understand what that means. COVID-19? No, I don't know. No, I mean, what does that mean? COVID-19? What does that mean? Right. No, I would say not. I mean, what does that mean? COVID-19? Does that mean, is that the, is that a force majeure notation on the bill of lading? I can't imagine that that has anything to do with it. So if they marked it COVID-19, that means it was shipped during COVID-19. Does that mean that there was a shortage? No. I still think that that's invalid. No, I can't see how that would apply to anything. I really have a problem with it. If somebody is seeing that, please send me an email on that. I'd love to explore that a little bit more. You have my emails. Please, I just put it back up because I want to see some emails from you on these type of issues. I'd love to explore that a little bit more. That's an interesting issue, actually.
Thank you, Jerry. And I may be able to unmute the individual who asked the question. Let me see if that's possible. Perhaps they can provide you a little bit more on that. All right, Michelle, are you able to speak?
Yes, hi. My name's Michelle Nelson. I work for LT Apparel, and we've recently gotten, I've seen some bill of ladings or PODs actually from one of the large carriers that we have, and the signature is showing either COVID-19 or COVID-19 as the signature. And I'm assuming it's because the receivers and the carriers want to maintain that 6-foot distance. And I'm just wondering if that was something that was, that the receiver could say, well, we didn't receive these cartons. It's signed COVID-19. So how can you prove we actually received that?
Well, that's why I'm asking you to please send me that. I would like to explore this a little bit further with you. This is the first time I'm really hearing of this. And I'd like to talk to my partners about it and get back to you on this and really give you maybe a better answer. I don't think it has validity. So in essence, they're saying this is not a shipper's load and count because we have to maintain our distance and we can't look into the trailer. I'll get a pair of binoculars. I don't know what to tell you, but that's not going to work for me. So yeah, I really would love you to email me this, and I will not disclose the name of the carrier or your company, but I'd like you to send me a copy of the bill of lading and your company, and I'll call you and discuss this with you. I'm very interested in what you're getting here.
I will
If you
definitely
wouldn't
do that.
mind.
Thank you.
Yeah, if you wouldn't mind, I'd love to, because I think my partners and I would be very interested in this. Okay, so thank you. I appreciate it. That's a great question.
Jerry, just so you're aware that that's maybe a tip of the iceberg type of thing, we do have another attendee who is saying that they also have a ton of PODs signed that way with COVID-19. They will also contact you directly via email. Someone else has
Please.
noted that they have heard about the COVID-19 issue, that it was due to the consignee was not allowing delivery in person, and so they were not able to obtain a delivery signature from the delivery location. So perhaps that is a contributing factor there.
That we've heard a lot of. There was also a lot of force majeure situations floating around. If you understand force majeure, in other words, it was impossible to deliver because of COVID. And a lot of my shipper clients and consignees, such as some big retail outlets that I represent, clothing and other stores that were actually could not receive goods, they had to play ball, so to speak, on a lot of things that were occurring, and they had to they really let things go because they knew as things turned around, they were going to need these carriers, and so they let things go for a while. So I don't know how each company dealt with this situation. It was a hard situation. Goods weren't being delivered on time. Of course, we know stores were closed for a period of time. Goods were stacking up, being non-delivered. It was a mess out there. And, we had some of our clients writing force majeure letters. It was crazy. Again, I hope most of you have contracts with your carriers. And if you don't, please, the first thing you need to do, that person that was shipping to Target, if this is your carrier you're using, you need to have a contract with that carrier. You need to have a contract with that carrier. And if you don't, your company is being foolish. That's the only way to do it. Say it. You're being foolish not to have contracts with those carriers. Just absolutely foolish in today's day and age. Next question.
Thank you, Jerry. Can a shipper file a claim with a carrier if they are not the ones paying for the freight charges, such as with collect shipments?
Yes.
Yes, I can. Okay. Excellent.
Yeah, sure.
Excellent. Thank you. Is freight collect, FOB destination, a legitimate term or condition of sale?
Well, that's what we went through. FOB, what is it? FOB?
Freight collect / FOB destination.
So freight collect means that the consignee is responsible for the freight charges. And FOB origin means that the loss, once the shipper gives the goods to the carrier, the loss is on the consignee. Now, the problem with that in most cases is that your retailer, who's sometimes the 800-pound gorilla, as we say, doesn't see it that way and is going to charge back to the vendor And that's where you get into the situation where you say, I just said, that the vendor can file that claim against the carrier because it's really suffering the loss in this particular case. Even though the risk of loss is on the consignee or the retailer, the real person that's suffering the loss because the retailer is charging back to the vendor, he's really suffered the loss in this case. And you know what? The law is very strange on shipments. The consignee sometimes will reject a shipment and send back the entire load. And it's not supposed to do that. The consignee is required to accept the loss unless it is practically worthless. It is required to accept a load unless it is practically worthless. So, unless it is totally destroyed, it has to accept the shipment unless it is totally worthless. Does that happen in the real world? Not necessarily.
Thank you, Jerry. John, I see your second part to this question further down. My apologies, I didn't see it initially, but I think that Jerry has addressed it in his response. If you need more information, please reach out to him via email. And I have two other questions in the queue, and at that point, I think after that, we will have to call the webinar. So, second to last question is, can the shipper file a claim on a collect shipment FOB origin?
On a collect shipment FOB origin. Yeah, freight collect. Yes, FOB origin. Yes.
Yes.
I mean, if it suffered the loss, who suffered the loss? That's what you have to look at. All right. So freight collect means that the consignee paid for the freight charges, and FOB origin means the risk of loss is on the consignee. But if the consignee, this is what I just said, if the consignee charges back to the vendor and the vendor actually is suffering the loss, then yeah, the vendor can file the claim. It depends on who suffers the loss here. Okay, can they file a claim? Yeah, but if the vendor didn't suffer the loss, anybody can file the claim. You can file it on behalf of the consignee if you want to. But if you didn't suffer, it depends on who suffered the loss. That's what you got to look at, not whether it's FOB origin or destination or freight collect. Freight collect shouldn't really play into it. Freight collect is for freight charges. That shouldn't play into it at all. Freight collect, that's why I pointed those things out. Freight prepaid or collect shouldn't play into it at all. It's really risk of loss that plays into it. And who actually suffered the loss is more important, since most vendors deal with a retailer who's going to charge back to them. That's where you have to look into. So if your retailer, although they may have suffered the loss, is going to charge back to the vendor, and the vendor is actually suffering the loss, which is what I see in your group most of the time, then that vendor should be able to file the claim against that carrier.
Thank you, Jerry. All right, so our final question for today, and I think there are some other questions that have come in, and please reach out to Jerry with those questions directly. He's agreed to be a resource for you to the extent that he can be. So our final question is, does SLC still stand in a multi-stop shipment?
Freight loss.
Does SLC still stand in a multi-stop shipment?
FLC, I'm not sure what it means. FLC.
SLC, I'm sorry, Sam, Larry, Charlie. SLC.
Oh,
still stand?
SLC.
Apologies.
In a multi-stop, no. The obligation of the carrier on a shipper's loading count on a multi-stop shipment is to count the goods at the first stop. They have an obligation. Once that seal is broken, they have an obligation, and most contracts will state that, but they have an obligation to count the goods on an SLC shipment at the first stop. And if there is a loss, they have an obligation to report that loss at the first stop. And contracts should state that. Our contracts do. I have contract language. I think I did include that in there. I guess we didn't get to that. Yeah, I did. Well, that was concealed loss and damage. But on SLNC, if you send me an email, I'll send you language on shippers load and count, what the contract should state, or what should be done on a SLNC shipment where there are multiple stops. But absolutely not. It doesn't apply all the way through. Absolutely not.
Well, thank you again. And unfortunately, we are well out of time. We are 16 minutes over the time, so we will have to close out the session at this point. On behalf of RVCF and Jerry Smith, we would like to thank you for attending today's webinar. A link to the on-demand version of this webinar will be sent to you following our program once that file is available, as well as a link to the presentation deck. And for those of you who have questions about the material covered in today's presentation, please feel free to contact Jerry at gsmith@pshslaw.com or gsmith@transportlaw.com. Thank you all and have a great day. And thank you, Jerry, very much.
Thank you very much. Thank you, everybody. Appreciate it. It was a great summer. You guys are wonderful. Thank you.
Thank you kindly.